Mr. Fields is here today after failing to appear before the domestic relations referee on August 4th, 2023. Bond is currently set at $1,570. This is the first bench warrant. He reports no employment. There have been no payments made on this account. Front of the court requests that a reasonable bond be set on this matter and it be scheduled for hearing on June 26, 2024 at 8:45 a.m. before this court.
Thank you. Mr. Fields, you're before the court charged with civil contempt of court due to your failure to pay child support and or related expenses and appear at a hearing previously in this matter. Upon a finding of responsibility, if you would, in this matter, on a first offense, you could be sentenced up to 45 days in jail. Or if it's a second or subsequent offense in this matter, up to 90 days. You understand the charges?
Yes, sir. I also would like to bring to your attention that I am currently unable to work due to medical diagnosis. I was
Well, what you're going to have to do is you're going to have to provide the front of the court with medical documentation to, basically delineate that. Are you able to post a bond, sir?
I'm not able to at this time. I had to contact my father. He is my, he caretakes for me. I'm unable to open my jaw. It's wired shut. I have medical appointments this week. Thursday at 3 p.m. I was to see my oral surgeon about my jaw.
Okay.
I'm on court on medical ordered 6 to 8 weeks of bed rest, and that could even extend even longer.
Okay. Well, what I'm going to do is, again, it is a first offense, so the court's taking that into consideration. But again, you've not made any payments, so I'm considering that. But what I'm going to do is I'm going to reduce your bond in hopes that you could be released. I'm going to set your bond in the amount of $300. If you're able to post that, you'd be able to be released. Do you have any questions?
Not at the moment, Your Honor.
Okay. Thank you, sir. You're free to go. Have a good day.
Thank you, Your Honor.
This is here today in the first matter after failing to appear before this court on August 9th, 2023. And in the second matter, the failure to appear was before referee Snyder on March 25th, 2024. In the first case, bond is currently set at $9,430. This is the fifth bench warrant. In the second case, bond is currently $715, and this is the second bench warrant. He reports that he is employed at Hoffman's. Last payment made on these accounts was in May of 2023. Front of the court requests that reasonable bonds be set in these matters and they be scheduled for hearing on June 26th, 2024 at 8:00 a.m. before this court.
Mr. Morris, you're before the court charged with civil contempt of court due to your failure to appear at a prior proceeding as a result of your failure to pay child support or related expenses. Upon a first conviction, you could be ordered to serve up to 45 days in jail. If it's a second or subsequent offense, up to 90 days in jail. You understand the charges?
Yes, I do, sir.
Okay. And purpose of this hearing is to set a bond that would assure your tenants at the next hearing on June 26, 2024 at 8:00 a.m. Are you able to post a bond in this matter, sir?
Yes, I can post a bond, just not of that much. Nobody can access my accounts while I'm in here.
Okay. Do you know how much you're able to pay? Because you have a sizable bond at the current time.
I could probably post a bond of somewhere around 11 to 1,500.
Okay. What I'm going to do is on the 2015 case, I'm going to set your bond in the amount of $1,000. And then on the other case, I'm going to set it in the amount of $300. So if you're able to post the 1,300, you'll be able to be released. Do you have any questions?
I do not. I thank you, sir.
Okay, thank you. Have a good day. We'll note the appearance of Mr. Schaefer on behalf of plaintiff and Ms. Capture on behalf of the defendant. This matter is before the court on the defendant's motion for relief from judgment. Ms. Capture.
Thank you, Judge. As we stated in our motion, Mr. Murphy entered into this agreement on the understanding that Ms. Taft was terminally ill, and based on her representations to Mr. Murphy would be dying within the year. The agreements that he agreed to essentially are unconscionable, especially given the fact that there is a massive divide between Mr. Murphy and the children now. He doesn't have the parenting time that he would have wanted, but obviously gave more parenting time to Ms. Taft, given her assertion that she was dying. He wanted to keep things as even for her. Even isn't the correct word, but essentially he wanted to make sure that she would have a decent rest of her life. So they didn't divide the business. A lot of the things that they kept around, like the country club dues, the tickets for the baseball and football or basketball and football games. Essentially he agreed to this under the understanding that she was going to be passing. If she's not, and he has tried to communicate with her and say, hey, what's actually going on? Because I'm being told that you aren't terminally ill. And that you induced me into agreeing to this agreement without under a false allegation. So essentially, Your Honor, what we're asking for is an evidentiary hearing so we can put proofs on the record to say Mr. Murphy did enter into this agreement under duress, that he believed false information presented by Ms. Taft. Even within his pro-con, he stated, and I'm not going to quote this directly, but he stated an understanding that he was entering into this agreement due to her terminal illness, without counsel, without representation, and simply signed the dotted line due to the misrepresentations that she placed to him. So, Your Honor, we're looking for an evidentiary hearing to prove that misconduct did occur, and then to move forward with this matter. Thank you.
Thank you. Mr. Schaefer? Can't hear you, Mr. Schaefer. You're muted.
Your Honor, we have filed an extensive answer. This number one, we submit that this is an improper motion for a number of reasons. Number one, the allegations alleged that my client said are not true. Next one is that it's pretty clear that it's under duress, pressured based on the allegations therein. Number three, this was filed because my client hasn't died yet. Well, they didn't even give her a year. It's February 29th judgment. I represent to this court melanoma. It's in remission at the present time, and to see that there's something inequitable about this. What is improper on this is that counsel for the other side signed these pleadings knowing that the business was owned by both of the parties. We have submitted evidence of that, and this was filed just before there is a oppression suit that is going to be filed in relation to the division of the business. Client is asking for costs and sanctions in that regard because both the client and the attorney signed pleadings knowing that there's a 50-50 ownership in the business. My client has never used her melanoma in any way to affect judgment. It was a choice by the defendant not to be represented. He had been represented around this matter and chose not to. That was his decision. Now he is crying sour grapes. His allegation about the children, his relationship with the children at the time was poor at best and did not exercise his parent time at this time. We submit that this motion is unfounded in fact and law, should be dismissed, and that costs should be assessed in relation to the improper pleadings.
Thank you. Anything else, Ms. Capture?
Your Honor, the pleadings aren't improper. Again, this is not so much about the allegations that this is a jointly owned business. We admit in our motion that there's a marital interest in this. Again, Your Honor, this is simply about the misrepresentation by Ms. Taft that she's terminally ill. She induced my client into signing a divorce decree to get this settled so that she could live in peace the last time, however long it was going to be. Mr. Murphy has requested on numerous occasions, can you just communicate with me about what's going on? And she refuses to. And now he is being told by her numerous friends and family that she is not in fact terminally ill, nor was she ever terminally ill, and that he agreed to this under the misrepresentation that she was. Again, Your Honor, we state in our motion specifically that we are just simply asking to have all of this resolved. However, Ms. Taft will not communicate. And if she is going to continue living, which is great, good for her. We want her to be in remission. We want her to be healthy. But if she's going to continue, obviously the marital property needs to be divided appropriately, including the business. That's not to say that we are saying, well, we shouldn't ever divide the property. We simply need an answer, and we need the correct answer, not a lie. If she's going to be passing on, well, then let's get that resolved, and we would withdraw our motion. But we obviously, she's in remission, allegedly. So then she obviously didn't have terminally ill melanoma like she represented to my client.
Well, in this matter, the court does note that fraud has been alleged, but as I go through the pleadings here, the argument, there's been very little factual basis for the allegations. I don't believe that in this matter, the defendant has set forth a prima facie case for the court to again intervene at this time. And so the court believes that if in some time if the defendant can develop those particular facts, then the defendant can file an amended motion in this matter. But at this point, the court doesn't believe that there's a factual basis in this matter other than a he said, she said. And as a result, the court will deny the motion at this time. And the court doesn't believe there's a basis for award of costs or fees. So it will deny that request by both parties and ask Mr. Shaver, you prepare the order denying the motion.
I will, Your Honor. Thank you.
You're free to go. Have a good day. Court will note the appearance
Thank you,
of Ms.
Judge.
Henderson on behalf of plaintiff, Ms. Capture on behalf of defendant. The matter is before the court on the plaintiff's motion to modify judgment of divorce concerning parenting time and support. I don't need a rehash of this. So as you probably know, we have 11 motions at 9 o'clock. So we're really stacked up. So if you would just, again, respond to whatever the other party's answer or motion is stated. And I do note that in this matter that the motion, and that states that Ms. Hunter, basically, who was tasked with developing and overseeing parenting time, can't or won't do it at this time. So matters come before the court at that point. Anything else, Ms. Henderson?
No, Your Honor. Essentially, the parties have joint physical custody without specific parenting time. Upon conversations with Ms. Hunter, she stated her license does not allow her to do what the judgment tasks her to do. So based on the factual impossibility and also pursuant to MCL 72227A, we're simply asking for a specific parenting time to be developed. Ms. Hunter stated there's no reason why my client cannot exercise 50-50 parenting time. I think a brief evidentiary hearing with Ms. Hunter's testimony would be very helpful for the court to put something in order for specific parenting time for my client to be exercising, Your Honor.
Thank you. Ms. Capture?
Your Honor, I am aware of Ms. Hunter's position. I believe the most appropriate thing here is that we select a different parenting time coordinator, like Meredith Katz. The minor children have stated animately that they do not want to have a relationship with mom. This needs to be dealt with between a counselor. Right after the most recent incident where the minor children confronted mom went over to Mr. Johnson's home and physically assaulted him. There's now a PPO. Her boyfriend was also there and assaulted Mr. Johnson. And so the timing of this motion in particular is a little disturbing when what we truly need here is a counselor to facilitate discussions between the minor children who are both 14 and 17 who refuse to have a relationship with mom given her erratic behaviors.
Okay.
Your Honor, if I may have a brief
No,
response.
I don't need that. Ms. Capture, how about as recommended that we maybe go to Ms. Katz? What are your thoughts on that?
Your Honor, I don't think there is any dispute that Ms. Hunter is helpful to the family. I don't know if Ms. Katz's license would allow her to provide a schedule to the family either. But essentially, we want something that could be enforceable and something that could be followed by the parties. Mr. Johnson has refused any sort of parenting time to Ms. Johnson. This is why we would like Ms. Hunter to provide testimony regarding that. And as to allegations about domestic violence and or PPO, those are under court proceedings. Currently, my client is objecting to both of those matters. So, Your Honor, I would ask for the court to schedule an evidentiary hearing for Ms. Hunter to provide her testimony. The parties are continuing counseling with her, and that is one of her recommendations, but there's no parenting time that she can develop for both parties to follow.
What the court's going to do then, in this matter, we don't have an agreement as to how we're going to proceed. The court will refer the matter to the referee for an evidentiary hearing on the issues of parenting time and support. And you'll get notice as to when that hearing is. You're free
Thank
to
you
go.
very
Have a
much,
good
Your Honor.
day.
Thank you.
Court
Thank
will
you,
note
Judge.
the appearance of miscapture on behalf of the defendant. This matter is before the court on the defendant's motion to extend discovery and modify the case scheduling order. In this case, Ms. Osborne, you've probably read the motion. Do you have any problem with extension of those deadlines and moving the mediation to August?
Yeah.
Ma'am, I'm asking you, not a third
Yes, I'm
person
sorry.
in your office.
Yes, I believe I'm fine with that, certainly.
Okay.
Yes,
Well, with that in mind, Ms. Capture, the court will grant your request. Will extend discovery through August 1, 2024. Have mediation in August with the requested mediator, Mr. Brundage. Ms. Osborne, do you have any problem with Mr. Brundage serving as the mediator?
not at all, Your Honor.
Okay, Ms. Capture, you can finalize that in an order and submit it to the court under 7 days.
Thank you, Judge. I appreciate it.
Thank you. You're free to go. Have a good day.
Okay, thank you. You too, Your Honor.
Court will note the
Bye-bye.
appearance of Ms. McNiff on behalf of plaintiff, Ms. Capture on behalf of defendant. This matter is before the court on the plaintiff's motion for temporary custody, parenting time support, and to restrict, again, someone of the opposite sex on an overnight basis with when the children are present. Again, I don't need a rehash of the motion. Ms. McNiff, have you received Ms. Capture's response?
I have, Your Honor.
Okay, if you want to respond to that.
Well, briefly, first, we're not asking for a restriction against members of the opposite sex, but rather a restriction against persons with whom either party has a sexual relationship. We don't want to expose the child to any new partners at this point. And that doesn't necessarily mean that the person would be of an opposite gender. The parties have been having a nesting situation, essentially, wherein during the week, each party has the child for approximately half of the day, which means that they are exchanging parenting time almost on a daily basis during the week, and then on the weekends they're alternating. This is not a tenable situation moving forward. My client would like to move to Livonia to stay with her parents temporarily while she's able to seek a better job and obtain housing for herself and for the minor child, and to continue with this nesting arrangement simply won't work if my client moves back with her parents. We're asking for sole physical custody, but I understand that this court often maintains the status quo. However, the status quo with this nesting arrangement isn't going to work. And so we would ask first that my client be granted sole physical custody of the minor child, or in the alternative, that the court grant the parties joint physical custody pending an evidentiary hearing on the issue of custody on an alternating week basis, so that they can actually separate themselves. It's my understanding defendant would like to keep the marital home. We're not disagreeing with that. However, again, this back and forth is a lot of exchanges between the parties. So we believe that given the past CPS complaints, and there have been two, both were not substantiated. There was one each against each of the parties, one against defendant for emotional and verbal abuse, one against plaintiff for failure to protect. But again, those haven't been substantiated. But because of that, we have concerns about defendant's ability to properly care for the child's emotional needs. And that's the basis for our request for sole physical custody.
Okay, Ms. Capture?
Your Honor, as we stated within our answer, there are no concerns. CPS has no concerns. My client is actually a DHS worker. There are no concerns with regard to her and maintaining a healthy relationship with the minor child. Obviously, the last 8 months they have been participating within this nesting arrangement. The parties recently lost their daughter in a foster care removal due to the allegations that plaintiff alleged against my client. However, despite that, they do have a healthy relationship. They've come together on multiple occasions and supported each other on parenting. Again, 8 months of status quo is very impressive. Now, I will agree with Ms. McNiff and state that a everyday handoff is not necessarily the most efficient. However, the 223 would be very tenable for these two parties. The minor child does have autism and a few other, or not autism, I apologize. He's got a few needs that he gets services through the county. Specifically, essentially all of his doctors are. Is Lisa gone?
Yeah,
Oh, wait, sorry.
you chase her off, Ms. Capture.
I'm sorry. All right.
Okay, go ahead and continue, Ms. Capture.
Again, I apologize, not autism, speech therapy. So he's engaged in speech therapy and physical therapy here in the county. He's lived here his entire life. He is an adopted child. He does have siblings in this area still. So the two parties have a strong connection to Calhoun County. We would strongly oppose plaintiff moving out of county all the way to Livonia with the minor child. It would be very far against the status quo. And essentially, Your Honor, what we're asking for is the status quo, just a 50-50 arrangement between the parties. The parties have made agreements about Disney World in the coming months. I believe my client has purchased tickets, and that's been all approved by plaintiff. And so in total, these parties do tend to co-parent very, very well. Obviously, it's a breakdown to the point where the nesting arrangement no longer works, and defendant would like to move back into the marital home and give plaintiff the opportunity to find other alternative housing.
Okay. Ms. McNiff, I do note in the, a lot of time was spent in the answer talking about the, again, the move back of the defendant into the home. Are you opposing that?
We are not opposing that, Your Honor. And just briefly, my client has the ability to move. Even if the parties have joint custody, she can move within 100 miles. She would be moving within 100 miles. The child is 4. The child is not yet in school. And so I think that this is an issue. Where the child will go to school, where the child will ultimately live, is an issue for an evidentiary hearing. I think without having all the evidence, the court can't make that decision. What we know right now is the parties have been splitting custody, but again, splitting custody on a daily basis is not a long-term plan.
Okay. Well, what the court's going to do is the parties have been able to work together, and the status quo is then that they've had joint physical and legal custody. So the court's going to continue that joint custody on this matter, with parties having the child on a 50-50 basis. The court will, I do note that obviously if somebody moves, whoever moves, that person is not, we're going to have some issues as it relates to transportation, all that. The court will at this point allow the parenting time to occur on alternating weeks, starting at 6:00 p.m. on Friday through the following Friday at 6:00 p.m. The court will basically set support consistent with this particular arrangement. The court will acknowledge, as the parties have stated, that the defendant will move back into the home. So the court will grant to the defendant the possession of the home. I'll leave it up to the parties to try to work out a time frame for that to occur. And if you can't get that, then come back to the court in this particular matter. And so that will be the temporary order of this court. I ask Ms. McNiff if you would prepare that order and submit it under 7 days.
I will. Thank you, Your Honor.
Okay, thank you all. You're free to go. Have a good day.
Thank you, Judge.
Court will note the appearance of Mr. Toth on behalf of the plaintiff, Mr. Sullivan on behalf of the defendant. This matter is before the court on the plaintiff's motion to modify judgment of divorce. In this matter, Mr. Toth.
Thank you very much, Your Honor. Your Honor, primarily we're here this morning regarding 5-year-old Will, although I think that the intent of our motion was to try to address issues related to the younger of the two minor children, Hawkins. The parties share joint legal custody. They have a disagreement. I think everybody agrees with that. In essence, Your Honor, my client, following what he believes were recommendations both from Bright Lights as well as recommendations from the CISD, was that particularly Will, the 5-year-old, but really both children, should be attending a preschool program. A preschool program is not daycare. This isn't Mr. Stewart's first experience as a parent. He has, from a previous marriage, has 2 adult children and dealt with educational issues through their entire lives. They did well. They're doing well as adults. And he believes that in situations such as this, you should rely upon and take into consideration the recommendations of the professionals. In essence, it appears that we have Dad, Mr. Stewart, who would like to see the more formal preschool program to help particularly Will transition to kindergarten successfully, whereas Ms. Stewart, the defendant mother, prefers that her mother remain engaged. And although it's hearsay and of no real evidentiary value today, I found the letter authored by the maternal grandmother in this case is very, very interesting. And these are her words. At this point, Will meets or exceeds the requirements for kindergarten readiness with the exception of the area of social emotional skills. Both parties are in agreement with that, Your Honor. I think it's how it wants to be addressed, whereas the maternal grandmother prefers to address it in a less formal setting with peers, continuing what she's been doing, which again, there's no disagreement that she's an ex-teacher and understands the educational component of it. Everyone agrees that the socialization is not being met. And in kindergarten, it's such things as stay in your seat and stay in line, and this is what task you're doing now. That can be accomplished in a quasi-classroom setting with peers, many of the same children who are going to transition into the kindergarten class, which I think even the defendant's mother would acknowledge that would be helpful. So again, it would appear to be straightforward. And I think the real problem here, Your Honor, is the mischaracterization of the involvement of CISD as well as Bright Lights. Bright Lights offers a preschool program that is distinct from childcare. Bright Lights is more than a childcare provider. As far as the CISD, we all agree they determined that Will is ineligible for any services, but that doesn't prohibit them from expressing to Mr. Stewart and presumably to the defendant mother that in this particular case, Will would benefit more by the classroom setting. I think those are the issues. And quite frankly, Your Honor, if Will's going to go into a preschool program, there's no reason that Hawkins shouldn't also. So that's the request, Your Honor. I think it's simple. I think it's straightforward. If there's going to be a factual dispute, I think it ought to be resolved by the input of the professionals as well as the parents. We're not contending at all that the CISD or Bright Light should be making decisions that in place of the parents. It's rather taking the information that they have to offer and making then recommendations, and then the parents making a decision as to what's best for the children. And unfortunately, in this situation, they're unable to do so. At the time the judgment was entered, the younger child was 2 years old and the older child was 3 years old, and there was absolutely no way to predict the circumstances that would exist as they exist now. Clearly, it's a changed circumstance. Thank you.
Okay, thank you. Mr. Sullivan?
Thank you, Your Honor. First, I would indicate that I would oppose the idea that it is a changed circumstance sufficient to justify a hearing. First of all, the judgment of divorce was entered only approximately a year ago. The corrected judgment was entered in May of 23. And then getting into the nitty-gritty of the motion, it appears that a lot of the nitty-gritty has been kind of backed away from in this oral argument. First, the Plaintiff misquoted the provision in the judgment by indicating that they're to spend at least 2 days of work at Bright Lights Daycare. That's not true. And I quoted the exact language in paragraph 3 of the answer. Second, it is not true that CISD made any recommendation whatsoever about having either of the boys attend Bright Light preschool full-time in the summer. It's just not in there. As a matter of fact, the CISD work only focused on an evaluation of the older child for the purpose of determining the needs or whether there would be additional needs to be provided when he enters kindergarten. And along with that, the other area of inaccuracy in the motion is that they write in their motion that Will is at a stage of having the option this fall of either attending preschool or kindergarten. That's not true either. So their motion starts out with 4 or 5 factual inaccuracies that carries through and creates the theme of inaccuracy in the requests that they make. Getting to the social and academic, I ask that you take a careful look at the letter by Denise Myers, as well as Exhibit B, which is from Craig Bays. The social needs of both boys have been met entirely by the efforts of Denise Myers' grandmother and my client. And if you look in the various writings, particularly in section in paragraph 6 of our answer, and you look at all the activities that have gone on that these children have been participating in by the efforts of the mother and the grandmother. And I might add, when it comes to these activities, particularly the athletic activities, all of the costs of these activities have been paid by mother alone. They've been paid by mother alone. While I'm on the subject of the financials, Your Honor, the request that's being made by the plaintiff would lead to a financial increase that my client would have to incur from $126 a week to $378 a week, and including the fact that she pays all the extras for athletic, the equipment, the cost, etc. And it is important to note that if you look at the child support payments made by the plaintiff, they have been consistently and habitually late, nearly a month every month, which also puts my client at a financial stress point. So to add this additional cost when there is no benefit to the child, in fact, a detriment, it just doesn't make any sense. So when you look at the social that's being provided to the boys, it comes from mother, it comes from grandmother, maternal grandmother, Miss Myers, and it doesn't come at all from the plaintiff father. Also, as Miss Myers points out, we point out in our answer, there's a concept called social emotional learning that, of course, Miss Myers, you can see from her letter and that she's as expert as it gets in the area of providing toddlers and young children meeting their educational needs. And she talks about the need for social emotional learning and the need to have one-on-one with Will, particularly right now for that need throughout the rest of the summer to prevent him from what's referred to as the summer slide leading into kindergarten. And then with regard to Hawkins does not need social. I mean, he's very good socially. I think the parties would agree with that. What Hawkins needs and what Ms. Myers looks forward to is working with him one-on-one with his academic needs as he nears kindergarten. The answer also lays out a number of negatives that have occurred at Bright Lights, which collectively would lead clearly to the conclusion that more time at Bright Lights is not better for the children. Actually, less time or no time is better. And then with regard to the distinction that was drawn by Mr. Toth with respect to the child care half of Bright Lights and the preschool half, Your Honor, it's one building. The children go back and forth between the two halves freely. So to suggest that there's that kind of clear distinction between what goes on in that school is just not accurate. Finally, the motion seeks to take away parenting time from my client. My client is able to spend time during the week working from home with their children. And this current arrangement has been in place now for only a year. It's working as best it can given the nature of Bright Lights. And we're asking that no change be made other than perhaps having the children attend a different daycare, but that would be the subject of another motion.
Okay, thank you.
You're welcome.
Well, in this matter, the court has read the pleadings and heard the argument today. again, the court will note that, again, this recommendation from the CISD and all of that, those are just simply recommendations. They're not, again, it's not any evidence or anything of that nature. The court does note that, again, that the parties had in the judgment of divorce agreed to the 2 days a week at the Bright Lakes daycare. In this case, the court notes that the defendant has in their answer delineated the socialization that's occurring that's under paragraph 6. And then throughout the answer, there's also other statements as to what is happening in the way of socialization in this matter. The court does not believe that there is a basis at this time to modify or change the judgment of divorce. And as a result, the court will deny the motion at this time. Mr. Sullivan, you can prepare an order denying that motion, submit it under 7 days.
Thank you, Your Honor.
Thank you. You're free to go. Have a good day. Mr. Podell on behalf of the plaintiff, Mr. Todd on behalf of defendants. We have 2 matters before the court: the plaintiff's objection to order changing domicile and custody, and defendant's motion to change parenting time. Mr. Podell, why don't we start with you?
Thank you. Good morning, Judge. We filed our objection in this matter, Your Honor, because Mr. Weller indicates that, and he's not disputing whether Mr. Wesley Todd sent out a proof of service regarding this hearing. He's just saying he didn't get it. And from a historical angle here, Your Honor, Mr. Weller has always appeared at hearings. He's never missed a hearing. In fact, he's the one that initiated proceedings to establish a parenting time order in this case. It's his position that from what he could ascertain, Mr. Weller later learned that the motion was served on his prior counsel. And it may have been sent to her and Mr. Weller, but that attorney had rejected service. That's the information that he got when he contacted his prior firm that he had retained. And that he only later found out about the hearing after the fact. Suffice it to say, Your Honor, that if you look at the prior order that was entered in December of 23, it does grant Ms. Tyree sole legal custody, but I akin this to, you can paint stripes on a horse, it doesn't make it a zebra, because there are provisions in the order, despite the fact that it says that she has sole legal, that says that major decisions regarding education, medical treatment, and even to move out of state are decisions that need to be made between the parties.
Well, Mr. Podell, the judgment doesn't say the add on there or if they move out of state. It just says educational and medical.
And then for out of state, it just says that she has to seek court's permission, correct?
Yes.
And when we look at the motion itself to change domicile,
I'm not going to go back in and look at the motion. We're dealing with your objection and the defendant's motion to change parenting time.
Very well, Your Honor. So with that, Your Honor, he is objecting to the entry of the change of domicile. He believed that it's more akin to a change in custody. And I think that is really solidified in the motion to change parenting time, because the proposal is that Mr. Weller would receive all but the first, last, and a midweek during the summer, and then he would continue to enjoy holidays. But Mr. Weller already gets half the summer. So what the deal really is for Mr. Weller is that he would get an extra 2.5 weeks during the summer, and that's supposed to make up for all but the last weekend each month during the school year that he would normally exercise. And so I truly believe, Your Honor, that this really is a disruption of an established custodial environment with Mr. Weller, and it really is more akin to a change in custody.
Okay, thank you. Mr. Todd, what's your response?
Thank you, Your Honor. Your Honor, I think one part of the issue that the plaintiff does not understand is the prior order gives my client sole legal and primary physical custody. So the argument that this is akin to a change in custody doesn't really make sense, because she already has primary physical custody anyway. But beyond that, in terms of the objection, it is not accurate that it was only sent to his prior attorney. The proof of the service is on file contained within the motion, and we sent it directly to his address in Lowell. Additionally, the actual order was sent directly to his address. And then curiously, after the order was entered, then he objects. We don't believe that there's any real valid defense here because of the fact that my client does in fact have sole legal custody. We are requesting that the objection be denied in total, and we are requesting attorney fees. Service was proper. However, he did not attend the hearing. The time frame to object has passed. There's no allegation of good cause as to why he did not necessarily attend the hearing. There's no real meritorious defense, as my client has sole legal custody and primary physical custody. So we believe that the objection itself should be denied, and we are respectfully requesting attorney fees on that portion of the matter. In terms of the modification of parenting time, again, my client was granted primary physical custody. She is planning her move to Nebraska. In essence, defendant is receiving basically standard parenting time with one additional weekend during the school year. So we believe a most appropriate and pragmatic result is that the plaintiff would be given the majority of this, or all of the summer in essence, with the exception of 1 week before school and 1 week after school, and 1 week during the summer for my client to exercise vacation, and then outside of that, alternating holidays, and that he could have 1 weekend per month. This is substantially more than 2.5 weeks of parenting time. And again, it doesn't modify the custodial environment in relation to what's actually contained within the order. So we are respectfully requesting that change in parenting time and the objection itself to be dismissed in total, and requesting attorney fees for having to defend that.
Okay. Well, in this matter, the court did review the pleadings, and in this case, court does note that the court had previously granted a change of domicile pursuant to MCL 722.31. And as I stated previously, just because the order requires the parties to communicate on medical and educational issues, that doesn't change legal custody, which was granted to the defendant in this particular matter. The court does not find any basis to, again, revisit or change the order for change of domicile. So the court will deny the objection at this time. I'm not going to grant any costs or fees in this particular point. Court will note that the defendant had made a proposal as it relates to change in parenting time, obviously, presumably as a result of the move. There was a proposal under paragraph 5, and if the plaintiff does not believe that that is appropriate or agreeable, then the court would send the matter to a referee for an evidentiary hearing on the issue of parenting time. So that's what we'll do, Mr. Todd. You can do an order denying the objection. The court will refer it to the referee. If you get a agreement in, or I guess before that hearing, then let the court know and we'll pull that matter off.
Absolutely, Your Honor.
Okay, thank you. You're free to go. Have a good day.
Thank you, Your Honor.
Okay, Attorney Todd, I'm going. There we go.
It worked. All right. Turn this off.
Hello.
Hello.
I apologize. It wouldn't unmute.
Yes, that's okay. Do you know if your client, Michael Caldwell, plans on appearing this morning?
My client will not be here.
All right.
Court will note the appearance of Mr. Todd on behalf of plaintiff, Mr. Fisher on behalf of the defendant. The matter is before the court on the defendant's objection to the proposed order. Quite frankly, I expected the both of you to get this matter resolved in the interim, only because I do note in defendant's objection, he is more specific, but under Mr. Todd's order, he states the defendant is allowed to participate in disputed matters in this case, including mediation. I would assume that that would encompass everything that you'd put in your order as well, Mr. Fisher. So tell me why I shouldn't approve either one of them.
Well, I guess his order does not say what means or what actions I can take to participate in
Well,
disputed
I
matters.
stated you can participate in all disputed matters. So however those are, if there's a disputed matter, you have a right to participate, and that would include discovery or motions if you need to file those.
If that's the court's interpretation of his order, I have no problem with it then.
Okay. You don't have any problem with that, Mr. Todd, do you, if we enter your order with that understanding?
No, Your Honor. And
Okay.
in fact, I think the court, we have a scheduling conference later this afternoon to kind of review some of those parameters.
Okay, well, we'll address that, but that was the intent of the court, to allow Mr. Fisher to appear in all disputed matters. So I will enter Mr. Todd's order with that in mind and with that provision, Mr. Fisher.
Thank you, Your Honor.
Okay, thank you. Thank you both. You're free to go. Court will note the
Thank you.
appearance of Mr. Toth on behalf of the plaintiff, defendant appearing in pro per. This matter is before the court on the plaintiff's motion for temporary custody, support, parenting time, exclusive use. The court notes, as set forth in the motion, that the parties had apparently signed a consent judgment of divorce in this matter. Mr. Toth, you can proceed.
Thank you very much, Your Honor. As the court has just indicated, yes, that the parties did approve a proposed consent judgment of divorce, and I believe that there's also been a default that's been filed against Mr. Whalen in this case. I would note that there has been no answer filed to the motion. I know that the parties have been talking, Your Honor, and there was perhaps a discussion about a resolution. I've not had any direct communication with Mr. Whalen. I don't know if that's the case or not. I believe that the proposal anyway was to, well, I don't know what the status is. My client advised me that that her husband was going to appear, so here we are.
Okay, so let's see what he has to say. Mr. Whalen, what's your response to the motion?
I'm kind of confused about the whole thing. I know I was supposed to go in and sign documents early this morning, but I'm just out of town and I got too short of notice.
Okay. Well, with that, you have any response?
Do I have a response, Your Honor?
Yes.
Yeah, there is a revised agreement that was supposed to be signed early this morning for me. It just hasn't been signed yet.
So Your Honor, with those statements from Mr. Whalen, I think that perhaps the best way to proceed would be for me to go ahead and identify what I believe the terms of the agreement to the temporary order were, and that if he then agrees, then I'll go ahead and prepare it, and I can just go ahead and then notice it for entry, given those statements. So Your Honor, what we're looking for would be more specificity to, well, let's start with the easy part, which would be the exclusive use of the marital home. Mr. Whalen has moved to, I think he's living in Kalamazoo now. He has his own residence. My client has remained in the marital home, and actually it's separate marital property, or separate property as opposed to marital property. And she would simply like an order that would grant her temporary exclusive use of the house. And she would retain all obligations to maintain it, pay for it, pay the taxes and the insurance during that period of time. As we move forward to the issues relating to the children, Your Honor, the proposed judgment of divorce did not have a specific parenting time schedule. It was simply as the parties could agree. They've had trouble agreeing. So what we would be looking for would be an order that would be the standard parenting time schedule, which according to the Calhoun County schedule for alternating holidays and breaks, with a week on, week off summer schedule. The deviation would be in our prayer for relief in the motion. There was a provision that there would be no overnight guests / girlfriend during the pendency of this action. In other words, no overnight cohabitation. That will be eliminated from the order that I anticipate preparing, Your Honor. The school year schedule would be the traditional alternate weekend schedule with the midweek. And rather than recalculate support, Your Honor, we had a calculation attached to the proposed judgment of divorce based upon the Michigan Child Support Guidelines, and we would ask, or I would then include that in the temporary order. The temporary order would provide that the parties would share joint legal custody with the plaintiff in this case, as is indicated in the signed consent order, retaining the primary physical custody of the children.
Okay. With that, Mr. Whalen, is that what you are going to agree to?
Yes, that's correct.
Okay, thank you. Mr. Toth, you can submit that under 7-day, and or if Mr. Whalen wants to come in and sign, he can sign that, and we can take care of it in that manner.
I'll 7-day it, Your Honor. Thank you very much.
Thank you. You're free to go. Have a good day.
Bye-bye.
Court will note the appearance of Mr. Hauser on behalf of the plaintiff, defendant appearing in pro per in this matter. Mr. Mekediak, are you disputing the denial of parenting time pursuant to the show cause motion?
Yes.
Okay. If so, then what the court will do is the court will have to have an evidentiary hearing on the denial of parenting time. As it's stated there in the ex parte order, court will not change custody without an evidentiary hearing. So an evidentiary hearing would be necessary to do that. And that's by case law from the Court of Appeals Supreme Court repeatedly telling trial courts they can't change custody without an evidentiary hearing. The court would, however, as I did under the ex parte, would order that the defendant would not remove the children from the state of Michigan without court approval in this particular matter. And
Correct.
with that, I think that takes care of everything until we can get in and have a evidentiary hearing. Well, in both of these matters, I guess. Okay.
Your Honor.
Yes.
I'm going to be turning myself in the morning. I have to go serve 5 months in jail.
Oh.
I don't know how you would like to go about that.
Well, if you're not available, is there any problem with them placing the children with the plaintiff in the interim?
No, Your Honor. She's been charged with 2 counts of 4th degree child abuse. She is not allowed any no overnight parenting time, nothing.
Okay, well, I guess we're going to have to deal with that all at some later point. But if you're going to be in for about 5 months, we won't be able to have a hearing within that particular time. So, but
unfortunately,
well, we can always have a hearing because they can present you, and we can do that during Zoom. So we'll set up a hearing and then have everyone present at that time. Mr. Mekediak, you're going to have to make sure that you can, if there's anybody you want to testify or anything of that nature, you're going to have to make sure that you can get the subpoenas out, and that will all be by Zoom. Okay, sir?
Yes, sir. Thank you so much, Your Honor. You have a blessed day.
Thank you.
Your Honor, is the evidentiary hearing that was just mentioned as it relates to the show cause going to be separate than the friend of the court evidentiary hearing currently set for June 25th?
Oh, what's the June 25th date?
That was in relation to the continuation of the friend of the court hearing that we began up in Grand Traverse County that was objecting to the custody order that was put in place back in December before the case was transferred over to Calhoun.
Okay. Well, we'll have that matter. The show cause will come up at the same time. Recognize, Mr. Mekediak, what county are you in that's going to happen, that you're going to go to jail?
Otsego County.
Okay. I just want to know so we'd be able to make contact with you.
Yes, sir.
Okay. Thank you. You're free to go. Have a good day.
Thank you, Your Honor. You have a blessed day as well, sir.
Thank you very much, Your Honor.
Okay. Court will note the appearance of Ms. Reed on behalf of the plaintiff, Mr. Bartel on behalf of the intervening party. The matters before the court on the plaintiff's motion to stay pending appeal. Mr. Bartel has filed an answer. Ms. Reed, I don't need to, again, rehash your motion. If you want to respond to anything in Mr. Bartel's answer, go ahead.
It's just that we're dealing with a constitutionally protected right in this matter, Your Honor. We do not believe any evidence has been presented to rebut the presumption that is in place to protect that right. There is no risk of harm to the child with a denial of grandparenting time. There is a risk of harm to the child if grandparenting time is exercised, because this child does not want to see the grandparents, and to call her out of the house kicking and screaming would be traumatic to her. And that there has not been a best interest finding pursuant to MCL 722.27 B6, which is required by the court to conduct and place that finding and that analysis on the record, and that hasn't happened yet. So how this order kind of got entered, allowing grandparenting time, is backwards, is that all the requirements were not met. So we're requesting that the effect of the order be stayed pending appeal, or that it be rescinded and we go to an evidentiary hearing regarding the presumption and the best interest factors.
Okay. Mr. Bartel.
Your Honor, this court has every right under MCR 3.207A to issue a temporary order with regard to, quote, any matter within its jurisdiction. And that is right on point, Your Honor, and that is quoted from the court rule. And grandparenting time is within this court's discretion or within this court's jurisdiction. So clearly the court has the ability to enter a temporary order. It is a little confusing from plaintiff's motion It kind of vacillates back and forth between whether this is a final order or a temporary order. Clearly, it's a temporary order. They would need an interlocutory appeal in this matter. The court weighed everything that was put in the motion in answer at the previous motion hearing, determined there was a preponderance of evidence to rebut the presumption of the statute. Further, as we had put in our motion, the court had previous hearings in which this court had heard from Mr. Cronkite, and he had been under oath previously, where he had said that the grandparents were the ones who were really watching the grandchild and not Taylor Morgan. And then he does an about face under oath again when it is convenient for him to say, oh, they never even watched really the kid at all. So, Your Honor, I think that motion before the court here should be denied, since the court has every right and authority pursuant to the court rules. Thank you.
Thank you. Well, at the time that the court put in place the temporary order, the court did note, as stated by Mr. Bartell, what the status quo was, which is now disputed. And the plaintiff has delineated many reasons in the motion. But the court would note that, again, those are just allegations and conjecture at this point without having a hearing in this matter. And the intent was the court would have a hearing, but I was only maintaining the status quo on a temporary basis at this point. The court will not stay the order. If the Court of Appeals wishes to do so, they may do so during their review, but the court is going to deny the motion to stay the order in this matter. Mr. Bartell, you can prepare an order denying that motion, and that will conclude the matter for now. You're free to go. Have a good day.
All right. Thank you.
Court will note the appearance of Ms. Redmond on behalf of the defendant. This matter comes before the court on the defendant's motion for temporary support, custody, parenting time. Ms. Redmond.
Good morning, Your Honor. I apologize for the confusion. I had a technical difficulty, and so I'm using Ms. Moss's computer.
Okay, go ahead.
Thank you. Again, good morning. Ms. Grapp and Mr. Cady have been separated since February of this year. Ms. Grapp currently has a PPO against Mr. Cady and is living in the home with the 3 children. Mr. Cady has not had overnight parenting time with the children since separation and has instead exercised non-overnight parenting time around 2 times per week. We are asking that this schedule continue, that she be awarded temporary sole physical and legal custody for the pendency of this action, that Mr. Cady be awarded parenting time on Fridays from 1 to 5 p.m., Sundays from 9 a.m. to 1 p.m., to reflect the current schedule that the children have been used to since February separation, and that Mr. Cady's income be imputed to reflect the potential income of a computer programmer, which is his training and past experience in the area for at least part-time work. Ms. Grapp does have concerns about Mr. Cady having overnight parenting time, including the special medical needs of the children. Aurora, who's 11, has diabetes. Mr. Cady has in the past routinely slept through her blood sugar monitor, has returned Aurora from parenting time to Ms. Grapp with expired glucose sensors. He has also in the past refused to take Burko, who was only a few months old at the time, to the emergency room after that was recommended by a medical professional. He even threatened to crash the car that Ms. Grapp and Burko were in when she requested that he take them to the emergency room. Ms. Grapp had to wait until they returned home, and Mr. Cady fell asleep on the couch to be able to take Burko to his emergency room for care. And she is worried that that the children will have similar, that Mr. Cady will not be able to make decisions in their best interests if he does have overnights, considering their medical needs. He's also been violent towards Ms. Grapp in the presence of the children, including threatening to break down the door of the children's bedrooms while the children were inside it. And she fears that he may be violent and aggressive towards the children if she is not there to intervene like she has in the past when they did live together. As well as that, his housing situation has been unstable. It is our understanding that he's moving into a new apartment. He has lived with his parents, again, to our understanding, living outside the home, not in the home. And again, Ms. Grapp believes his housing is unstable to support overnight parenting at this time. So for those reasons, she's asking for that specific parenting time, non-overnight, Fridays and Sundays, to reflect what the children are used to, what their routine is, as well as to protect them in their medical needs, their special medical needs, and for their safety.
Okay, thank you. Mr. Katie, what's your response?
Sorry, this takes me a while. Okay, so to address some of this in order here that she just said it. First of all, it's what she said about the current schedule of me seeing the kids is omitting the fact that they expect me to have it 1 hour every day. Currently at 7 p.m. to 8 p.m. But before I even say that, let me say I've said to Ella over and over that I'm available 24/7. I've been trying everything I can to get more time with my kids, and I don't have enough time with them to provide anything like I could and I did in the past to them. And oh yeah, I'm sorry. I actually, before I address what she just said, what Ms. Redmond said,
Just go ahead and address something, sir. I'm way behind on my hearings, and respond to the emotion.
Okay, no, but I have to explain that we are homeschooling parents, and the educate. So the kids don't go to school. We educate them at home. So I gotta talk about that just a little bit, and to explain. It's different from most parents. Yeah, and I'm sorry about. I'm trying to be quick here. It's very hard for me, but okay. So yeah, we are homeschooling parents, and I did in the past. I was able to have enough time with them where I could educate them, and I can't do that under this schedule, and they rely on, and Ella even relies on me and my help for the homeschooling, and has always. Okay, so but anyways, the current schedule is not as she said, and it also hasn't been going on. She said it's going to go on since February, but actually there was a period where we had a 50-50 sharing agreement, which is what I'd like to ask for as a temporary schedule. But that 50-50 agreement wasn't overnight, but it was supposed to be 50-50 trading days. And it worked a lot better for our family. And the kids don't want to keep the current schedule. They are really excited about staying overnight with me. They've said it again and again, especially my younger daughter, and even my son Berko is not speaking, but too young. But I mean, I can you can read his facial expressions. He's well, okay. Anyways, so even what she said about the current schedule is not true. It's very important to have that hour together with those kids. At one point, we were taking daily walks for that hour, but Ella wouldn't let that happen. And so the best we could do was a 1 hour virtual meeting. But I've actually spent a lot more time in that hour because I've been able to she's also been relying on my mother for babysitting, and during a lot of the time when she's relying on my mother for babysitting, I also spend time with the kids. So she's vastly understating the amount of time that the kids have with me, and the fact that they expect and hope for more, and so do I. And I've always been, and my two daughters and myself have all been pushing to get more time. And that's why we even have that much time in the first place. Excel has been resisting that. Okay, so then I want to talk. The next thing, I think that handles the first thing she said. The next thing she was talking about is the medical concerns, and if I could, I know I have to be brief here, but if I could go into detail, I mean, it would sound really. I think her claims would sound really silly, but I'm going to try to explain. Well, one thing is that as far as like decision making, I mean, we have a whole. I mean, okay, so actually, let me talk about the overnight sleeping through the alarms. Okay, so both of us would sleep through alarms until one of us got up to get the alarm, and she would usually get it. But that's but let me tell you, as a programmer, I wrote a program to plug the alert system into that would provide a second alert system using the stereo speakers, and it would blast the audio enough to wake up everybody in the house. And I mean, that's how serious I was taking this, when we were together, and that system, we stopped using it because Rory was getting up herself with the alarm system. But so we haven't had that system in use, but I built that system and I take it very seriously, treating Rory's diabetes. And I took it I learned a lot about endocrinology, and so there's a story that I want to tell. The first night, that we were in the hospital with Rory, when she had ketoacidosis, so she had to go to the ICU, pediatric ICU, and I didn't know about type 1 diabetes. And Ella, actually, to her credit, she diagnosed type 1 diabetes, and I didn't believe her, and not only that, the urgent care didn't believe her, and it turned out that she was right. And but anyways, we ended up in the ICU, and I just spent all night studying endocrinology, and I told Ella that we should go on a low carb diet. The whole family, not the whole family needs it, but for Rory's blood sugar control, and otherwise. Well, anyways, I was reading all about that. Then we talked to the doctor. The doctor recommended against that.
If you would confine yourself to the issues of custody and parenting time and support. You're getting off on a lot of tangents.
I'm sorry.
I don't have time for that today.
I'm sorry. Well, if I could just finish the story, the doctor recommended a diet. We tried it for a year. Then we tried what I recommended, and it worked. And the doctor said, you can't argue with the results. And, I'm just saying, I'm taking medical decisions for Rory very serious. I take her type 1 diabetes very serious. I put a lot of effort into that. Okay. So the next thing she said, she said I refused to take Burko to the hospital, but I drove him all the way to the hospital, and I turned around because she didn't have her phone. And, I felt like we needed that phone. I went back to get the phone, and I was too tired to drive. And she got a ride from my mom. It was okay. But she's just telling the story with all these facts omitted. She's made claims, allegations that are going to fall apart if we can examine them in enough detail. And I know we can't today. But they will. I have a lot of evidence I've collected of our recordings of our conversations that will. But okay, so there's that. I think okay. So another thing about the fact that we're homeschooling is that we don't have any kind of schedule, and we're not just homeschooling. We don't have regular jobs. We don't have any kind of schedule conflicts to work around. There's no reason to limit my time to the weekend. But Ella's doing that. Ella has insisted that it has to be Friday night and Saturday morning. So another thing about the established, I'm sorry, I forgot to say this before, is that she says that what the kids are used to is 4 hours per day, but that's not true. What they're used to and what they expect and ask for, they don't even have to ask for it. They expect it. And Ella has initially resisted, but now she no longer even resists to the kids. That they stay until bedtime with me, and then I send it back. And even then, my younger daughter, she always asks to stay overnight. She doesn't want to go back for bedtime to mom. Not that she doesn't want to sleep there, but she hasn't had enough time with me. They know that they lost their dad almost. That it's been reduced to these video meetings 1 hour per day that are not as satisfactory as in-person time. There's no more education provided by me, and I can go into detail later, I guess, but I've been driving the educational planning and the education for the family. Even
sir, you need to conclude, please.
Oh my gosh. Okay. So yeah, and also I have a great place for them that they really love. They really want to spend time there. They really want to spend I'm sorry, I'm just looking at my notes here on the table here. Okay, see if there's anything else I can throw in here. So another thing is that we had a lot of standards that were kept for our kids that have declined in the household without my help. And Ella herself would benefit hugely if I could have the kids more, and she had more time to herself, to clean the house and to
Okay, I'm not concerned about any time she has for herself. Just address custody.
Well, it would be good for our kids,
please.
Right? Because the house, Ella has. All right, so yeah, for to be able to take care of herself, it would be better for the kids if she had more time, to keep the house up, which is not being done.
Please conclude, sir.
All right. Sorry. What I was trying to say there is that Ella by herself is forced to lower the standards that we had previously established on diet, education, paying attention to the kids, attention given to the kids, and language practice for my young son who's just learning language. And also, I didn't address, she's talking about imputing income for a programmer. And I mean, I'm not trying to avoid making income. I'm doing a lot, you know, to try to make income, not by getting a job though, because I mean, the market for labor here really isn't available to me. So, but I have, you know, I have an independent research career that's been not financially successful, but it has, you know, resume
Okay,
points.
thank you, sir. I don't need to hear anything else. Go ahead.
Sorry.
The court's going to, in this matter, court's heard the, again, the evidence, or at least the allegations in this particular matter, read the pleadings. In this case, what the court is going to do is the court will grant to the defendant temporary custody, subject to parenting time with the plaintiff. Court notes, based on the parties' schedules, they haven't had anything consistent. They don't work consistent jobs. What the court's going to do is grant to the plaintiff parenting time on alternating days from 12 o'clock noon until 4 o'clock p.m. each alternating day, starting on June 20, 2024, and each alternating day thereafter. The court will order that the parties would exchange any income information that they have within 7 days of today's date. Again, if we don't have any income, or if it's sporadic, the court will impute to each party the sum of $15 per hour on a full-time basis. The court would order that the parties would communicate through a communication app such as Our Family Wizard or Family Close or any of the other apps that the parties can agree upon. If not, then they'll use Our Family Wizard. And I'll ask Ms. Redmond that you would prepare that order and submit under 7-day notice of entry.
Yes, Your Honor. Thank you.
Thank you. You're free to go. Have a good day.
You too. Thank you.
Thank you.
Court will note the appearance of Ms. McKenzie on behalf of plaintiff, Ms. Podolsky on behalf of the defendant. The matter is before the court on the plaintiff's motion for modification of parenting time. I have read all the pleadings in this matter. I don't need you to reiterate that, as I have a lot of motions yet to address. So if you could maybe respond to the other parties, again, pleadings. Ms. McKenzie.
The court wants me to respond to the extra items in Ms. Podolsky.
Respond to Ms. Podolsky's answer in this matter. I've read your motion. I don't need you to reiterate your motion.
Okay. With regard to the answer, the Mr. Howe's older child is going to be switching schools. That's one of the allegations in Ms. Podolsky's answer. And so he will be attending the Portage public schools. So that is a non-answer. The fact that the child is only in first grade and is not doing well bears some consideration in this matter, because the Portage schools offer a greater amount of opportunities, and I expect that the child will be able to thrive and do better in a larger district where she can have multiple opportunities during a single day. There is an allegation in Ms. Podolsky's answer that the child is receiving certain help under Title I. Well, that is a federal program that is available to all schools and would be available if both parents feel that it is benefiting their daughter. That is available at the Portage schools also, because it's federal money. So I believe that we are simply asking for a modification of parenting time that is consistent with the case law. And in addition, under 722.27, which defines the established custodial environment, there would not be a change of established custodial environment, because the child is still going to look to, if she is permitted to attend the Portage schools, where she would live with daddy during the school year, Sunday through the following Friday, the established custodial environment would not change, because the child would still look to the custodian in that environment. So daddy during the school week, during the school year, and mommy on the weekends and during vacations. So she would naturally look to the custodians that she now looks to for guidance, discipline, and the necessities of life, as well as parental comfort. This is simply designed, this motion is designed to give her greater opportunities, cultural opportunities, academic opportunities, dramatics, music, and so forth, because she would be attending a school with the advantage of a larger district, which does have a good reputation in the greater Battle Creek, Kalamazoo community. So we're asking the court to entertain the idea of allowing the change of schools for the reason that the child will have the opportunity for greater advantages due to the largeness of the school district. But this opportunity is still not going to change the established custodial environment, which is and will remain with both mom and dad. Thank you, Your Honor.
Thank you. Ms. Podolsky?
Thank you, Your Honor. As we stated in our response, this motion was improperly filed. The issue of changing a school district is an issue regarding legal custody, and this was a motion to modify a parenting time schedule. What we have here is the plaintiff is getting married and moving to Portage. As we stated in our response, he's going to continue to work here in Battle Creek, and that was not denied by counsel today. So if the court were to entertain this motion and then ultimately decide that this minor child should move to the Portage School District, we'd still have both parents here in Battle Creek and Calhoun County during the work and school day while this minor child is in Portage. This happens frequently when parties move to the next county over, whether it's Jackson County, Kalamazoo County, and it does not necessitate a school change. Right now, she is in a smaller school district. They have assessed her for her needs. They have a plan in place for her. As we stated in our response, it is my client who is solely getting her to summer school this summer. The plaintiff is not participating in that program, despite alleging that the minor child struggles. This proposed change is going to make her, a small fish in a big pond, and nothing in their motion stated why this would be a benefit for her and what could be offered for her. What was stated is the plaintiff is getting remarried and moving to Portage, and therefore all of these changes need to occur. That is not the case. The motion is improper. They have not cited proper cause or change of circumstance to make this change. And on top of that, their proposed schedule would result in my client losing 1 month of parenting time per year. When these parties have joint custody, week on, week off, 50-50 parenting time, 1 month out of 6 is huge. That's a 20% reduction. So we're asking this court to deny the motion in its entirety and order that the status quo continue as it relates to custody, parenting time, and the school district, which is currently Penfield. Thank you.
Thank you. Ms. McKenzie, any response?
No, Your Honor.
Okay. Well, in this matter, the court does note that the judgment of divorce entered on December 5, 2022 does provide for joint legal and joint physical custody, and as stated, the parties have been exercising that in alternating weeks. The plaintiff seeks to modify effectively the parenting time, and the court takes that as really seeking to change custody. The court does not believe that proper cause or change in circumstances has been presented to meet the Vadbarka threshold sufficient for an evidentiary hearing, notwithstanding the fact that the motion is calling it parenting time as opposed to custody. The court also does not believe that the threshold has been established for a Lombardo hearing concerning the school. So the court will deny the motion at this time. Ms. Podolsky, you can prepare that order and submit under 7-day.
Thank you.
Thank you. You're free to
Thank
go.
you,
Have a
Your
good day.
Thank you.
Court will note the appearance of Ms. McNiff on behalf of plaintiff, Ms. McKenzie on behalf of defendant. This matter is before the court on the defendant's motion for attorney fees and costs. Ms. McKenzie.
Thank you, Your Honor. We're asking the court to require Mr. Fields to pay attorney fees and costs for this matter because the defendant is not able to bear the expenses of continuing to defend this custody matter. We have filed pursuant to MCR 3.206 parent D, which does allow a party to petition the court at any time. And I have specified the reasons that Ms. Bird is unable to bear the expense. And I have alleged pursuant to the verified statement filed back in January in this case, Mr. Fields did under penalty of perjury indicate that he earned $2,000 per week, which would be a total of $104,000 every year. Ms. Bird has consistently attended school. She has graduated from PA school. She is involved in the physician assistant profession. She is wishing to go to the state of Tennessee to pursue that goal and to be with family and provide her children with additional maternal family companionship. And she has had to resign her position in order to take a position in Tennessee but there's a gap of time for her to get licensed. And so she is still working at the previous employer, but only on a contingent basis. And as of June 13th, she had received only 36 hours. So there's a gap of time for her to be able to earn a consistent, predictable income in the state of Tennessee in her profession, which she spent a lot of money on obtaining school loans and is repaying her school loans. Because she is departing the Battle Creek urgent care position early, she's paying $833.33 per month. She has a penalty, a breach of contract penalty, a stipulated agreement for $10,000, and that is being paid off at $833.33 per month. But if the court looks back a little bit, she was forced, because of domestic violence, she was forced to leave the household and did not stick around to collect any money, ask for any remuneration for her part of the household that the parties were living in at the time that she needed to leave for her safety because of domestic violence. So Mr. Fields has a home with 30 acres, and he has all of the furnishings and additional personal property items, plus the contribution that Miss Bird made to his purchase of that home. Miss Bird sold her home that the parties were living in.
Mackenzie, I'm not going to readdress any property dispute that or resolution in this particular matter. So
I'm simply explaining, and I'm almost done. I'm simply explaining why Miss Bird is in the financial situation that she's in right now. Part of it is the having to leave the job to take the job in Tennessee, which does not start now until the middle of July.
why did she resign so early when there was a gap then? Why didn't she wait and resign prior to going to Tennessee then?
She believed that she would be starting earlier in the state of Tennessee, and the position that she's taking is a Michigan-based firm starting to provide healthcare providers such as physician assistants in the state of Tennessee. Their time frame changed after Miss Bird resigned from the Battle Creek position because she did not intentionally cause the gap of time. So the start date became a moving target, but that was after she had resigned from the Battle Creek urgent care employment position. So she's faced with this, but she did take it upon herself to work for the very same employer as often as she can. She's working contingent, but like I say, that hasn't resulted in a whole lot of hours. But I think the court does need to consider that she started at a disadvantage because she did not get any funding, any financial consideration for setting up her new household when she had to leave the household. So, there was a financial issue anyway. She's paying just under $1,200 for child support. She's having to repay $833.33 per month as a settlement rather than face a trial, a breach of contract, and a very expensive court proceeding with regard to the urgent care company. So she's simply running out of money, Your Honor. And the Court Rule 3206D does allow her to petition the court. But I did want the court to have the background of she's not been a wealthy person for a number of years, and she does have school loans, which she's paying back. And as I mentioned in the pleadings, part of the school loans were there were certain parameters that she was eligible for, like those of us who've gone to law school. You're eligible for so much. She maxed those out in part to pay for living expenses for the plaintiff as well as the party's children when they were residing together. So any savings, any financial plus that she might have had does not exist for each of those various reasons. She's expecting to be able to recoup all of these, get back on her feet. I'm not sure recoup, but get back on her feet and provide well for the children by taking the new position in the state of Tennessee. But at the moment, the earliest date is going to be the middle of July.
Thank you. Ms. McNiff, do you have anything to add other than what was contained in your answer?
No, Your Honor.
Okay. Well, in this matter, the court notes that the defendant has attempted to bring up the issue of property division. That was taken care of well before this particular issue, so the court's not going to take that into consideration. The court will note that she resigned her position in Battle Creek to start a job in Tennessee, which now won't start until mid-July. Court is looking at Michigan Court Rule 3.206 parens D as to whether the party shows they're unable to bear the expense and the other party is able to pay. The court does note that it does appear that the defendant's problem and difficulties at this time occurs because she voluntarily quit her job, thereby leaving her unable to pay her attorney fees and expenses. And court will note the defendant is responsible for her own self-inflicted financial position, I guess you'd say. It's not anything attributable to the plaintiff in this matter, nor would it be a normal situation. She unfortunately got caught in some issues concerning the start of the job and that, but that's by her own doing. In this matter, the court will find that the defendant has not established a basis for attorney fees in this matter, so the court will deny the motion. Ms. McNiff, you can prepare the denial and submit under 7-day notice of entry.
Thank you, Your Honor.
Thank you all. You're free to go. Have a good day.
Thank you, Your Honor.
Judge, this was a case that the proof of service was. Okay, let's see.
Proof of service, what?
Didn't indicate how the hearing was going to be held.
Oh, okay.
Hopefully this is.
Mr. Pratt, the court will note the appearance of Mr. Pratt on behalf of the defendant. This matter is before the court on the defendant's motion to dismiss the prior action. I think it's the one pending in St. Clair County. Let's see if this is Miss Akers.
Yes.
You are Miss Akers?
Yes.
Okay. Go ahead, Mr. Pratt.
Thank you, Your Honor. James Pratt on behalf of Mr. Brandon Mosteller. Judge, I know you've reviewed my motion. This is basically a motion for summary disposition pursuant to Michigan Court Rule 2.116C6. There is a prior pending action in the Court of Competent Jurisdiction here in St. Clair County where jurisdictional requirements were met. Our action was filed on April 25th, and Ms. Brandon Mosteller's action was filed in your circuit, the 37th Circuit, on May 3rd. We're simply asking that this matter be dismissed and that the St. Clair County proceed. It's my understanding that Ms. Smith Akers has retained, and I know that's not relevant to you, Your Honor, but has retained counsel for our circuit. Ms. Erica Kern is my understanding. I have incurred, I know that in my motion in the summary or the prayer for relief that asked for attorney fees in the amount of $1,500. I just calculated my actual time, including this morning, of 1 hour. And that's of course, to the honorable discretion of the court, but that my fees in terms of filing, drafting, motion, etc., $1,195. I would ask that. Simply, I don't think there's bad faith, but I think that if the court were to look at your 37th Judicial Circuit Court pleadings, I just found it interesting, and I indicated that in my motion that Ms. Smith Akers actually used 31st Circuit Court summons paperwork, and that was subsequent to our filing here in the 31st Circuit Court. And that's my request for relief, Your Honor.
Okay, thank you. Ms. Smith Akers, what's your response?
I was working with legal aid starting April 5th, and I was working with Fiona, an attorney at legal aid. She was drafting up all the paperwork for me to file here in Calhoun County. So I was waiting on her to finish up. Brandon was able to file the paperwork before me. So he got it in on April 25th. I wasn't able to file mine until May 3rd because I was waiting on Fiona, the attorney from legal aid. So I had no clue that he was filing. I don't see why I would have to pay his attorney. I mean, I understand the whole, there can only be one case. I do understand that. I do understand I wasn't first, so mine will need to be dropped.
Okay.
But
Okay.
yeah, I was working with an attorney.
Okay, thank you. Well, the court does note that the matter was filed in St. Clair County on April 25, 2024. That as the plaintiff herself acknowledges, this action wasn't filed until May 3rd, 2024. And the court will say pursuant to the case of Mulford versus Stender at 215 Mish 637 of 1921 case. The case where the action or the case where the first action was filed obtains jurisdiction to hear the matter. That was St. Clair County. And as a result, the court will dismiss the Calhoun County action. And the court will leave the issue of attorney fees and that to the St. Clair judge as you proceed in that action. Mr. Pratt, you can prepare an order and submit under a 7-day notice of entry.
Thank you, Your Honor.
Okay, thank you.
So the issue of attorney fees, Your Honor, would be preserved to be adjudicated by the 31st Circuit?
Yes, your judge down there as he takes all the other testimony in this matter. And again, he clearly has the jurisdiction that he can decide those matters.
Thank you, Your Honor.
Okay, thank you. You're free to go. Have a good day.
Thank you, Your Honor.
Thank you. You as well, Your Honor.
This matter is before the court on the defendant's motion to set aside referee recommendation. Ms. Thompson, in this matter, you stated under your motion that says, I asked for alternating weeks.
Hold on, sorry, Judge. Sorry to interrupt you. The motion was filed by Mr. McKinney.
Oh, okay. I'm sorry. I'm sorry. I changed the parties around as I was looking at it. It was defendant's motion to set aside referee. And you stated, sir, in this matter, I asked for alternating weeks. I received standard parenting time and your support was raised. And you said, I quote, I feel this is not what is best for the child, end quote.
Yes.
Any factual or legal errors that you can point to that the referee made in this matter? I understand you don't like the results, but that's not a basis to object.
Yes. In the paperwork there was stated I only have 2 children. That is false. I am on support for more than 2 children. I have more than 2 children. That is a legal error.
Okay.
My other support was based off of that. Those are also dependents that I take care of. I have another.
What was that last statement? Other what?
Those are other dependents that I take care of.
Okay, no, you said you had other children. I did get that. Then what are these other dependents that you're claiming?
Yes.
No, who are they? I don't know. You haven't told me who they are.
I have children that I take care of. Do you need names? You want me to give you names, sir?
No, I want to know how are they related? Why are you taking care of somebody else?
I have Miss Thompson also has a daughter that I do for. I have children that are related to me that I do like activities with. As far as spending money, they're dependents. Like my sister, for example, her sons, I get him every other weekend.
Okay.
As well. My boy.
Let me tell you, sir, that's not going to change your support if you voluntarily assume responsibility for somebody else's children.
Okay, yeah, I understand. I was just answering your question. The only thing that I was trying to get corrected as far as that part was the fact that I have more than 2 kids.
Okay.
But like they are my biologically children.
Okay. Well, that would be a basis to change. What the court can do is the court will refer the matter back to the referee on the issue of support to take into consideration other children that you're paying support on. Anything else, Mr. McKinney?
Yes, sir. During the time that we had this hearing, I was explaining to him a situation that I had with a similar case. And I think he thought that that's what I was asking for with this case. I was not.
Okay. Well, I don't know. I don't know about that. I'm just saying what's been in your motion and what you've stated today. So
okay, before this hearing, me and Ms. Thompson had a conversation. Before I reminded Ms. Thompson about this hearing, she, I guess, changed her mind. Ms. Thompson is about to start working. I was going to keep my son while she was at work. She works Monday, Friday. And
okay, you can address that. You can address that prior to the next referee hearing, and then you can put that on the record if you're going to at that time. Ms. Thompson, is there anything else? Is there anything you have to say in this matter?
I have no idea what's going on, so no.
Okay, well, we'll refer it back to the referee because it does appear that there is a factual and a legal basis to review the support issue because of the other minor children that were not taken into consideration. So the court will do that, and we'll refer it back. You'll get notice from the front of the court as to when that hearing is. You're free to go today. Have a good day.
Thank you, sir.
Thank you.
Versus Lindsay Mekediak. In the first case, 113 PP, Attorney Huffman represents the respondent.
Good morning to all of you.
Good morning.
Good morning.
Court notes this matter is a continuation of the hearing commenced on June 10, 2024, in which testimony was taken from both of the parties at that particular time, and that we needed to acquire some of the exhibits that Ms. Huffman was not able to provide at that time. Those have been provided to the court. I will note that we do have the phone records from Verizon on the respondent's account for the month of January and February in this matter, but those were the only ones that I received. Ms. Huffman, were there any other that I was supposed to receive that I didn't receive?
I do believe there should have been an April 20, the last, sorry, I'm sorry, hang on one second. April, I'm sorry. March, the one in March, I do have that available to share. I believe that would be the only one the court should be missing. All the rest should be available to the court. And then we did have, I did provide a copy of the proof of service to the court. I believe Mr. Mekediak had a witness that he wanted to provide for that, but I'm not sure if he has that witness available.
Okay. Well, last week was the time and place set for those particular witnesses.
I have nobody in the waiting room.
There's no one in the waiting room, so there's no one to present, even if you wanted to at this time. Ms. Huffman, why don't you do the share the screen, and we can look at the March, because that is the only one that I'm missing.
Right, there's March.
And if you would highlight the March 18th, 2024 date, and if you could enlarge that so I can see it, because I can't see that.
March 18th is there. Does that highlight that for you?
Highlights, can you enlarge it though? That's what I'm looking at.
Yeah,
No, you took it away from me, so I can't see it.
is it gone now?
It's on the screen. Oh, okay, hold on. Put it back to what you had there. I could see it then, but it's on our large screen, but I have another one on my desk that it appeared on, but then it disappeared.
There we go. Is it? Whoops, sorry.
Okay, hold on. Don't touch it.
Okay.
You had it on my screen, and then whatever you did, it went off my screen.
Should be there for you.
Okay.
I'm seeing it highlighted.
One thing that will help here, Shelley, is for you to X that all tools on the left. That should give us more on the screen. That X that you have on that left, it says all tools, just go over to that X so you can collapse that side.
Nope, yeah, right there. Okay, great.
Yeah, that should look a little bit better.
I'll ask the petitioner, Ms. Mekediak, can you see that list of calls?
No, I cannot see it.
She's via telephone.
Oh, okay.
Can't see.
Going down there because I can't see it. Mekediak, I've got a number of calls, probably about 10 to 12 calls on March 18th. Just give me the first 6 digits of your phone number with the area code, because I don't want you to have to disclose your entire phone number. What is your area code, ma'am? 268?
But yes.
Okay.
But I would like to just mention something. if I can.
Yep, we'll give you time in just a minute. I was just checking out the list.
That's fine.
Okay, Ms. Huffman, if you want, you can take that down.
Your Honor, if I could just add that there, I believe, is a color photograph that we did present to the court that shows a car accident. It could be one in black and white, but it's a photo of across a guardrail, sorry. And then there's a wrecked car on the other side of that.
Okay. And what's the purpose of that?
That is my client's vehicle in Florida when it was wrecked in Florida, which is why he got the and there was a person that died in that accident. And my client had to get a rental car when he got back. And the only reason I'm provided that is because the petitioner indicated that the only reason my client would have rented a vehicle during the time in which we showed the court that there was a rental receipt would have been to drive the vehicle to Florida. That proves my client was his vehicle that was wrecked, and the reason why my client had to rent a vehicle when he returned back to Michigan.
Okay. And Ms. Huffman, are you offering the again, the picture and the phone records as exhibits in this matter?
I am. So the January, February, and March could be admitted as one exhibit A or one, however the court wishes. And then the pictures could be admitted as another exhibit.
Okay. We'll do that as exhibit 1 and exhibit 2. Okay. Anything else, Ms. Huffman?
I don't believe so. Thank you.
Okay. Ms. Mekediak, anything else that you have?
Just like to say that, calls are done and I via Wi-Fi.
Okay, ma'am, you're coming through. You're all jarbled, so I can't hear very well.
No, I'm sorry. Honey, okay, I'm sorry. The phone calls via Wi-Fi are not showing on here.
Okay, first of all, you're jarbled, and we've got a child screaming in the background. So,
nothing further.
Ma'am, why don't we do this? Why don't you disconnect and then reconnect? Maybe we can hear you better.
What's that?
Ma'am, end the call and then reconnect. And then we should be able, hopefully we can hear you better. She did. We had no problem hearing her last week.
Can you hear me?
Yes, we can hear you, ma'am.
Okay, I'm so sorry about that.
That's all right.
My son, he's autistic and I'm at a school, and so this is
Okay. Well, ma'am, first thing I want to ask is, in this matter, Ms. Hoffman has offered exhibit 1 and exhibit 2 in this matter. Do you have any response to the offer?
Just that with the phone calls, that if he was to call like via Wi-Fi, because
okay, ma'am, I'm just asking as it relates, ma'am, hold on, as it relates to any legal objection to the offer of those.
That it wouldn't show up on a phone record.
Oh, okay.
That it would not show his phone bill. Wi-Fi phone calls do not show up on a phone record.
Okay. We will address that.
App phone calls also do not show up on a phone record.
Anything else as it relates to that?
And I mean, other than, his situation in Florida, I don't know what his situation is.
Okay, well, let's address, I want to address, hold on, I want to address the exhibits first. The court will admit respondents exhibit 1 and 2 in this matter, there being no legitimate objection to those. With that, I guess, Ms. Huffman, you have nothing else. Is that correct?
I have no further evidence. That's
Okay.
correct.
Okay, Ms. Mekediak, anything else that you have in this matter?
Just that I was contacted and told that he was in Florida. Now his situation
Objection. I'm
Florida,
going to
I
object
don't
to that
know.
being hearsay.
Well, we've established he was in Florida, so that's, I guess, not a big issue. So go ahead, Ms. Mekediak, anything else?
That is just what he had stated to me. I don't know what his situation was. It's during his phone call, he had stated that he was in Florida. So,
Okay.
I mean, that's all I know. I don't know his situation of what took place or when he left or when he got back. I don't know.
Okay.
That's wasn't discovered over the phone call.
Okay. Ms. Mekediak, do you have any closing argument to make?
I mean, no, I guess not.
Okay.
No.
Ms. Huffman, any closing argument?
Yes, so I would just state that on February or for the February 11th incident, Ms. Mekediak several times stated that he was in Florida. She stated that it was FaceTime call, that she knew that he was in Florida. Just now she said that someone told her that he was in Florida. When she testified, she said he told her he was in Florida. I just objected to her as her stating that somebody told her that as hearsay, but she said that anyway. The court allowed it, so I'm just saying that's what she just said right now, is that someone told her. And her, if I could just give my argument without interruption.
Yeah, Ms. Mekediak, do not interrupt.
Thank you. My client simply wants nothing to do with Ms. Mekediak. He wants to get his divorce over. If that hasn't ended yet, last I knew, I think it was still open. He just wants to be divorced, to be done with her. He wants absolutely nothing to do with her. He's not contacting her. There's no proof that he's contacting her, even though she said for his January 27th call, that it came from his phone. Specifically, it says, I spoke to both of them and it was from his phone. I provided the phone records for January, February, and March. None of these, in fact, not just those days, but every day. And none of the days have any calls to either of her number or her son's number, which she stated he also called her son's number. Those numbers are not on any of his records. The records come directly from his phone company. They don't take numbers out to satisfy what Ms. Mekediak wants them to say. So again, I would just, there is significantly insufficient evidence to find violated any PPO. Thank you.
Okay, thank you. Again, anything else, Ms. Mekediak, before the court gives you a ruling?
No, he'll just keep bothering me.
Okay, thank you.
He bothers me with different people and him. So.
Well, if there's other people that are bothering you, you can always get a PPO against them. Again, that doesn't pertain to respondent. As a result, the court is not going to address that. Specifically in the petition to show cause in this matter, the petitioner had alleged various dates on which things she said occurred. The first date was January 27, 2024. Second date, February 7, 2024. Then February 11, 2024, and then March 18, 2024. She also claims that, again, there was a FaceTime call. I think that was the February 11, 2024 date. In this matter, the court has looked at the Exhibit 1 and looked at those particular records. The records show on the January 27th, 2024 date that she claims, and she delineated what the call was, etc., And the court will note that on his phone records, it does not show any calls from his phone to the 269-268 number, which she identifies as her number. Further, in this matter, that is the January 27th date, the February 9, 2024 date in which she delineated a call to her. That looking at the records, there was no call from his phone on that date. On the 2/11/2024, the date of the alleged FaceTime call, that in fact there was no FaceTime call on that. Plus, the testimony of the respondent was that in December 2023, that plaintiff had blocked him from all social media contact to him. Further, on March 18, 2024, which we saw today, there was no call to the plaintiff on that date from his phone call or from his phone number. Taking all of that into consideration in this matter, it does amount to more than a he said, she said, as he has provided documentation and evidence to show that he did not contact her. And as a result, the court will deny the show cause and deny any finding of contempt in this matter. The court will next go to the respondent's motion to terminate. He alleges that he did not do any of the things as alleged. Court will note that credibility is always a consideration in every case, and especially these types of cases. Oftentimes, a party will allege that the other party or one of their witnesses is not truthful or lying. The court has found that inconsistency in testimony does not mean that an individual has lied. Conflicting testimony can occur as a result of a witness's background, perception, bias, understanding, or misunderstanding or mistake. And when consistencies occur, the court will attempt to determine if they can be reconciled by other testimony or evidence. In this case, we have diametrically opposed testimony, so the court has to look at other evidence, and that other evidence is the exhibits that were submitted in this matter that shows that the respondent, Mr. Mekediak, has not contacted her in this matter. And so that evidence presented goes to, again, more than simply a he said, she said, but is backed up by other objective evidence to substantiate that, again, there was not contact. I'm not saying that there's not anything that's alleged to have happened in this particular matter, but it does, again, go to the issue of credibility when we have someone making various statements and then that testimony being, again, refuted by objective evidence in this matter. As a result, based upon that, the court will grant the respondent's motion to terminate the petitioner's PPO in this matter. And I would simply caution both the parties, don't communicate with each other, don't contact each other. And in your case, Mr. Mekediak, even though the court has terminated that, I'll let you know that the court could at some future point grant a new PPO if the circumstances warranted that. You understand that, sir?
Yes, sir.
Okay. Okay, that will be the order of the court, or the orders of the court in this matter. And we'll conclude this case. You're free to go. Have a good day.
Thank you.
Thank you so much.
Thank you. Have a good day.
For 2024-174 CB, Raspian Inc. versus Great Lakes Farms Properties and 4 other defendants. For the plaintiff, Attorney Kavanaugh. For defendants 1 through 4, Attorney Hubbard, and defendant number 5, Attorney Lipin and Frankel. And defendant number 5 is present here, Mr. David Kite.
Okay. Good afternoon to everyone.
Good afternoon, Your Honor.
I'll go with Mr. Kavanaugh first. Enlighten me what's happening in the case.
Your Honor, the parties participated in a facilitated mediation on June 4th with Ronald Strout as mediator. The parties went most of the day. They did not resolve the matter. However, the parties are continuing to work with Mr. Strout as mediator. None of the parties have declared an impasse. We are still talking. The gap is narrowing, and plaintiff would request that the court allow the parties to continue their settlement dialogue and potentially give us another 2 or 3 weeks before we report back to the court that we've either settled or not.
Okay. Guess Attorney Hubbard, what's your position?
Judge, we're fine with that. I would agree with Mr. Kavanaugh in that the parties have worked towards resolution here.
Okay.
There's been quite a bit of effort, and we would welcome the additional 2 to 3 weeks, Judge.
Okay, Attorney Frankel?
Hello, Your Honor. I'm Attorney
Oh.
Debbie Lapin. We're
Oh.
fine with that, Your Honor. We're not quite as involved in the discussions as the other two parties, but if they can resolve it, that's going to be wonderful.
Okay, what I'll do is, don't like to do this, but I'll have it reset for about 30 days, and we'll get you back in and then see what's happening. If we don't have resolution at that time, we'll set it for trial.
Judge, in terms of, I just want to raise at a high level now, if the parties are unable to resolve it, would the court have objection to giving the parties at roughly 45 days to round out discovery?
Discovery will be covered by what's in the scheduling order. I'm not going to set a new discovery date or anything.
Understood. Thank you, Judge.
Okay, thank you. Free to go. Have a good afternoon.
You too, Judge.
Thank you, Judge.
9 p.m. Attorney McNiff for plaintiff and Attorney McKenzie for defendant. Plaintiff is not here.
Well, good afternoon. Welcome back. Ms. McNiff, enlighten me. What's happening? What do you anticipate? Do we simply need to set the matter for trial?
I think we're going to have to go to trial. We've tried mediation and we were unsuccessful.
Okay, Ms. McKenzie, is that your understanding?
Yes, Your Honor.
Okay. What we'll do is we'll contact both your offices, see when you're available, and then we'll set it. Let's be, let's say, honest about this. How many days are you going to need for this case?
Well, honesty is my middle name, Your Honor.
Well, Lisa always tells me, oh, it's a custody case. Oh, it's 1 day or it's 2 days, and we end up 8 days or whatever.
I can't control opposing counsel's cross exams though, Your Honor.
Oh, okay.
Oh, yeah, okay.
That was not directed at Ms. McKenzie, however.
Oh, okay.
So,
we wouldn't want to do that, would we?
No,
absolutely
Okay.
not. But there are some people in this county who are a bit wordy.
Okay.
Realistically,
what do you think as far as the amount of time?
2 to 3 days, Your Honor.
I would concur with that.
Okay, well, we'll give you at least 3 then, and we'll find out when you're available, when we're available. It's probably, my recollection, we're probably not looking until August when we'd have 3 days available. Because I want to get them pretty close together. I don't want them spread out.
And I've got a 3-day trial in Branch County in August, so that's going to impact your schedule as well.
Well, we'll check with you then and see what we can fit in.
I say home county advantage. And Judge
Okay.
Kirkham calls Judge O'Grady.
Yeah,
The other one's in pending for 2 years though.
Oh, all right. That could be a problem.
Yeah.
That's not Judge Cherry down there. What are you talking about?
No, O'Grady. No, I said
I
Judge
know.
O'Grady.
I'm saying it's Judge Cherry. You had a custody case and you wouldn't get in for years.
I don't
is-
think
that is true.
I don't think those single judge counties care much about what SCAO says.
Well, I won't touch that.
We'll wait for the call from the
Okay.
staff. Thank you, Your Honor.
Yep. Thank you. You have a good day.
You too.
Bye.
Okay. Close the record.